Are you mad that Mandago was acquitted?
Usiweke maneno ya siasa kwa roho tafadhali. Weka kwa lungs. Ndio ukipumua tu after election. Akwenda.
This is the man. Can court convict somebody? Because every Kenyan wants that person to be jailed. Suppose the judge in the Albert Ojwang matter acquits. Everybody had an opinion that Mandago stole 1.1 billion. Hate Mandago. Hate anybody. If there is no evidence sufficient in court, the judge will acquit. The magistrate said, I know people wanted Mandago in, but the rule of law, there is no evidence. There is no evidence. Welcome to Court Helicopter Explainer Weekend Version. This was a justice week. We started with the murder of teacher Albert Ojwang. We came to the murder of Sharon Otieno by Governor Obado. All these was spread in Nairobi. Ojwang was in Kibera. Obado was at the prestigious, the tall Milimani High Court. While that was going in the High Court, a new development was happening in Nakuru. Mandago, senator for Uasin Gishu, was acquitted. Do you agree with the judiciary? Are you mad that Mandago was acquitted? The charges was that he had embezzled over 1.1 billion shillings. The public was expecting the courts to slay blood. The public wanted an Obando repeat in Nakuru, but we didn't get that. And the the magistrate who handled this matter, decided this matter at the no case to answer. Let me explain first of all, what is a no case to answer? After somebody has been charged, after Mandago has been charged, the prosecutor brings the evidence to court. All this evidence is given by state witnesses. Mandago's defense team cross-examines them, trying to show that the evidence they have is not credible. After all the witnesses of the state have testified, then the court directs that the advocates, that's the state counsel, the prosecutor, and also the advocate, the defense team for Mandago, make submissions for what is called a no case to answer. A no case to answer is simply like this. We, the prosecutor, we have brought our case. This is lorry road of the evidence. Put Mandago on the defense. Let him defend himself. The defense brings, they say, we have demolished this. These guys talked nothing. All they brought here is politics. All they brought here is not substantiated. All they brought here is hot air. The magistrate now decides. Did the prosecutor prove their case? Did they establish a case? In Mandago's case, the prosecution was found not to have proved a case sufficient to put Mandago on the dock. But let us know, who is this Mandago? Mandago was a former governor for Uasin Gishu, 2 terms. He finished his 2 terms. He came as a senator of Nairobi. Mandago is known for one thing. Raila Odinga and Uhuru Kenyatta were big-time enemies in elections. So, William Ruto and Mandago were part and parcel of Uhuru Kenyatta's government. One day, Mandago walks to State House and finds Raila Odinga in State House.
Imagine tumepiga kura ya rais, tukashinda free. Kotini kasema turudie. Nikasunguka kaunti 19 kuombea Uhuru kura. Na ule mtu ametuangaisha hapa ni Raila. Handshake ikafika nani? Raila sasa ndio wako bedroom State House.
And Mandago said,
usiweke maneno ya siasa kwa roho tafadhali. Weka kwa lungs. Ndio ukipumua tu after election. Akwenda.
This is the man. This is our guy. This is our topic of the explainer today. The famous Mandago. The allegation of 1.1 trillion. What did the judge, what did the magistrate deal with his case? In paragraph 98, the court says, there was no evidence of any express agreement among the accused persons herein to steal any money from the trust account. Number 2, further, it is tried to note that Mandago, the third accused person, signed the MOU publicly as a governor, and trustees operated and opened the trust account openly with approval of the bank itself. Paragraph 99, which is the killer punch. Finally, and of most important herein, is the fact that the investigating officer was put to task to explain how he arrived at this figure of 1.1 billion, which he explained that he added the cumulative amounts deposited by students. This was, however, contrary to the evidence given by the bank official, that was PW 137, who operated the account, who stated that at any given time, no such amount existed in the accounts that the accused would have conspired to steal. She stated that the highest amounts the account ever held was Kenya shillings 35 million. Look at it. The state sensationally said Mandago conspired to steal 1.1 billion. The bank came and said the largest amount that has ever been in that account is 35 million shillings. The magistrate said in paragraph 104, I thus do hereby agree with the defense that the prosecution's reliance on inflated lost figures while ignoring its own evidence of the task force analysis and flawed forensic mirrors the evidential gaps in this case. I do find that a prima facie case has not been established with regard to the first count, as there is no meeting of minds, and secondly, no evidence of any intention of capacity to steal. So the judge agrees that this was a sensational case, and in his conclusion, the judge is aware people, the public, wanted the judge to convict Mandago. And here is the conclusion. In making the final findings herein, the judge quotes the case of John Chebichi Sawe versus the Republic, where the Court of Appeal expressed itself that the suspicion may be strong, but this is a game with clear and settled rules of engagement. The prosecution must prove the case against an accused person beyond any reasonable doubt. In paragraph 138, The judge goes to India and quotes the case of Punjab versus Jagjal Singh, where he says, a criminal trial is not like a fairy tale where one is free to give flight to one's imagination and fantasy. It must be proved by evidence. It moves on to say, I find that the prosecution has failed to establish a prima facie case in any of the charges herein. The main reason for the failure of proof was that most of the witnesses herein were victims whose prayers was for refund. No evidence was led to link the accused persons herein with any criminal culpability. The administrative mishaps in themselves are not sufficient to lead to a conviction unless sound evidence as outlined herein above are proved to the required standards. Refunds can be sought in a civil forum, as the main purpose of a criminal trial is to punish an offender and not to collect debt. Let's also comment that most crucial witnesses failed to turn up, while those who turned up were beneficiaries of the scheme and therefore were not of much help in this case. So the judges say, the prosecution brought the students. The students cannot prove criminal liability. The students can only ask for refund. The parents can only ask for refund. And that's why the judge says, really, there was no evidence sufficient. Paragraph 40. With the failure by the prosecution due to lack of sufficient evidence, it shall be of no use to put the accused herein on their defenses, as that shall mean shifting the honors of proving their innocence otherwise to them. And that's why the judge, the magistrate, could not put this person on their defense. Failure to prove their guilt, they therefore constitutionally are deemed to be innocent. That is what our law provides. When some people may be unhappy, listen, the magistrate is aware. Everybody wanted Mandago. The way the public was baying for the blood of Obado, everybody wanted Mandago to go. The magistrate says, while some people may be unhappy with the presumption of innocence, it is a time-tested principle in all jurisdictions which apply democratic principles, and unless we opt to go the dictatorship mob way, we have no option but to enjoy it. This is the question. Can courts convict somebody? Because everybody, every Kenyan wants that person to be jailed. Suppose Justice Githua made a finding that Obado was not guilty. What could have happened? Suppose Major Mugure, the major of KDF, who killed his 2 children and the wife, was acquitted. Could the public demonstrate, cause chaos? Suppose the judge in the Albert Ojwang matter acquits. What will be the consequences? This magistrate quoted the famous case of Dr. Christopher Ndarati Murungaru versus the Attorney General and another. What is the import of this matter? Listen, when you go to court, you might be expecting somebody to be jailed. We saw the people of Migori come. They had a misconception. Lorry lots were there. People were there. Obado was walking in, greeting people in confidence. His defense team was confident he's going to be acquitted. The shocker came when one word was put: convicted. Let us look at what this magistrate says, and I quote, "The Constitution of the Republic of Kenya is a reflection of the Supreme public interest, and its provisions must be upheld by the courts, sometimes even to the annoyance of the public. We have said before, and we will repeat it, the Kenyan nation has chosen the path of the democracy. Our constitution itself talks of what is justifiable in a democratic society. Democracy is often an inefficient and at times a messy system. A dictatorship, on the other hand, might be quite efficient and less messy. In dictatorship, we could simply round up all these persons like Mandago we suspect to be involved in corruption and economic crimes and simply lock them up without much ado. That is not the path Kenya has taken. Kenya has opted for the rule of law, and the rule of law implies due process. The courts must stick to that path, even if the public may in any particular case want a contrary thing, and even if those who are mighty and powerful might ignore the court's decisions. So the magistrate said, I know people wanted Mandago in, but the rule of law, there is no evidence. There is no evidence. What did the magistrate do? I therefore dismiss all the charges against the accused person pursuant to the provisions of Section 210 of the Criminal Procedure Code, and consequently acquit all of them of the offenses of conspiracy to commit a felony, 2, stealing, 3, abuse of office, and forgery, contrary to Section 398, 393, 268(1), as read with Section 275, 101, as read with Section 102A, 345, 347D, all of the penal code, respectively, their cash bails deposited herein be refunded back to the depositors. Mandago and his co-accused were acquitted. What did the magistrate talk about the media? Court helicopter included. Listen, the media has been with us in these proceedings right from the outset till the end. They came in large numbers, as this was a public interest case, and I'm glad that their reporting was fair and accurately reflected these proceedings, and no part of these proceedings was misreported or misrepresented. Finally, and because I'm not an atheist, to the Almighty God for having kept us alive and safe till the conclusion of the trial hearing. This one, Bramwell had to go to Nakuru to look for it, because this is a magistrate's decision. What is the lesson in the Mandago matter? That everybody is innocent until proved guilty. 2, hate Mandago. Hate anybody. If there is no evidence sufficient in court, the judge will acquit. 3, a court of law is different from the court of public opinion. Everybody had an opinion that Mandago stole 1.1 billion. There was no evidence. Many of you remember that there is a time people want, the public believes this is the killer. This man has stolen money by corruption. Reaching in court, there is no evidence. You remember the evidence that was brought during Raila Odinga petition. Lorry loads carried. It was hot air. The judges and the courts are saying they will stand firm and only convict based on the evidence and the evidence that is there, the facts that are there, and the law. Okay, Danstan Omari has brought you I know you're part of the people who are bad, but that is the law. Keep watching as we bring you the latest decisions as they unfold.